Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is sufficient. I'm going to be candid with the court. There is a Supreme Court decision from 1996, Lambie State, and then there are 2 Court of Appeal decisions after that deal, and frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the reason...
Hi, treasures, and we're getting ready to start. We're going to listen to the closing arguments, and I think each one of the attorneys for all of the defendants are going to be speaking some. So let's get into it. Please like, subscribe, leave comments, and hit your notification bell so you know when we put out more videos. And thank you. It helps us a lot.
If a state stands up and says, well, there's no actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss. But the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have,
I don't think we need to have a new trial, so let's see.
If we show the court today, and I think we have through the proceedings today and before,
I do
that Ms.
too.
Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back all over again. If the appellate court say you were
Please.
wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law, and it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct box. But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up.
True.
But to get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete. And as Judge McBurney put it, actual and palpable, not speculative and remote. That's exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly couldn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years, and then she awarded him a contract.
Oh boy, yes
money,
she did.
Either from Fulton County or the state of Georgia, ended up in his pockets.
Right.
That decision alone was improper.
Not right.
But what's even more improper is that then she and he used that money to go on personal vacations and trips.
Not right.
If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back.
Here we go.
Because of the cash reimbursement theory, I'll talk about in a second. But if you do the math on what he actually paid for and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit when the best and first opportunity to raise
No,
that
there
issue would
wasn't.
have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for, and the state can't account for. And the reason we can't account for it
Who knows?
is because they
Probably
came
more.
up with cash theory. Cash theory only
Before we
raises.
get into that, let me ask you this.
Okay.
Let's say they couldn't have, let's say the theory wasn't even there that they had paid it back or that there'd been any exchange. Should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction or, it's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving a pack of gum is just justification.
There's
for
a little
disqualifying
bit
district
of
attorney. I
a
think that's
difference
part of the
here.
issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution,
Right.
and whether or not there's
Exactly.
an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts.
So what's the problem?
So in that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly. I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a total.
Why in the world are we wasting so much taxpayer dollars and other people dollars when it's all out there? This should already be over.
I think it's facts, and I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public,
And
cannot lie
that's
to
the
the jury.
state
And I think
he's
that's what he
talking
did.
about.
So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had two chances to correct information that he suddenly developed amnesia about, but he just didn't do it.
How does the timing of the relationship impact financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to. Every single question we asked Mr. Bradley was objected to. The jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper, and if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. If they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade, and they developed, in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn.
And there was the first attorney speaking on the closing argument. And we will see you on the next one. Remember, you're all beautiful and keep on smiling.